Hi, this is Mike Young, estate planning and asset protection attorney in Walnut Creek, California. And I'm going to talk a little bit about the question I get from my clients all the time. And that is, how do we keep our son-in-law or daughter-in-law out of our estate? But before I do that, hit the subscribe button below and hit like and make a comment. So let's say my clients are Bob and Mary, who I talk about all the time. And let's say they have a son, Ken, and Ken is married to Barbie. And as it turns out, Barbie has been married before and has several children. And as it turns out, also, Barbie is a spendthrift, and she spends Ken's money and her money on clothes all the time, nice clothes. And she buys shoes all the time. And she's just a spendthrift. So Bob and Mary, as I'm preparing their estate plan and I'm talking to them, they'll ask me, Mr. Young, how does this estate plan work with our assets? And I'll say, well, if Bob dies, everything will go to Mary. If Mary dies, everything will go to Bob, and vice versa. When you're both gone, everything will go to whoever you want, but I presume you want it to go to Ken. And they'll say, yes, that's what we want, Mr. Young, but we don't want Barbie to get it. And I'll say, well, that's fine. You know, in your estate plan, in your revocable living trust, we'll say that when the both of you are gone, everything will go to Ken. And that's his separate property. By California law, that's his separate property. It doesn't belong to his wife, Barbie. And it's his to do with as he wants. And Bob and Mary will say, well, thank you, Mr. Young, but that doesn't make us feel too good because Barbie has a very strong personality. And if we're gone and Ken gets our inheritance, Barbie will pressure Ken to commingle the funds, which is a legal term, which will make the funds both of theirs. And they'll say that Barbie will pressure Ken so that Barbie can spend all the money on whatever she wants, all of her clothes and her shoes. And they'll say, Mr. Young, also, what happens in their estate plan? Would it be set up like ours so that if Ken dies, whatever money he has would go to Barbie, including our inheritance? And they'll say, we're worried that if that happens and Barbie dies second, she will just give all of her money to her children. So how do we fix this? And, you know, a couple of things you can do. One is admonish Ken that this is what you want. You know, I can prepare a letter or something from you to Ken that states what your intentions are, that Ken not commingle the assets with Barbie, that the parents want Ken to know that that's his money. And the parents will say, Mr. Young, you don't know Barbie. And I'll say, well, what we can do is prepare a trust for Ken. And the trust will say, when Bob and Mary are both gone, Ken's inheritance will go into an irrevocable trust in Ken's name. And a third party would be named as a trustee to handle distributions from the trust. And in California, we have a term of art for a trust like that, that distributions could be made for the purposes of health, education, support, and maintenance. So the trustee, maybe it's a bank, would have the authority to make distributions to Ken. So Ken would go to the bank and say, bank trustee, I need some money for whatever the purpose is, for my health, my education, I'm going to go back to school, support, I need it to help with the mortgage or whatever it is. And the result of this is that Ken does not have direct access to the funds. And when Barbie pesters Ken for that trust money, Ken can say, it's completely out of my hands. I don't have the authority to make a distribution or to give any money to you. I'm sorry, Barbie, I can't help it. So, you know, that's what we can do. There's an expense involved because the trustee, maybe it's a bank or a third-party trustee, will want to be paid for their services, and accounting will have to be kept for the assets in Ken's trust, which would be irrevocable. And then that irrevocable trust would state that when Ken dies, everything would go to Ken's children and not to Barbie. So this would resolve the problem between Ken and Barbie, and Bob and Mary just have to feel comfortable with this scenario. They'll say, well, we don't want to upset Ken. If he sees this estate plan and sees that the money is just going to go to him, he might question it. And I'll tell him he doesn't have to see it at this point anyway. So these are some of the things we can do in order to keep a son-in-law or a daughter-in-law out of your estate plan. So hit subscribe below. I am Mike Young, Michael J. Young. My website is walnutcreekelderlaw.com. So go to my website and you can find my contact information, and feel free to give me a call or send me an email. So thanks for watching.